Hello, a warm welcome to you from SGT University. My name is Azad Singh from the Faculty of Law, SGT University. Today, we'll be covering written statement. Written statement. The defendant is required to file a written statement of his defense at or before the first hearing, or such time as may be allowed along with the list of documents relied upon by him. If defendant disputes the maintainability of the suit or takes the plea that the transaction is void, it must be specifically written. A general denial of the grounds alleged in the plaint is not sufficient and denial has to be specific. The denial should not be an evasive denial, but it must be point of substance. Every allegation of the fact in the plaint, if not denied specifically or by necessary implication or stated to be not admitted in the pleading, shall be deemed to be admitted. So dear students, now let's understand how to draft a written statement. When the defendant relies on several distinct grounds of defense or set-off, founded upon separate and distinct facts, they should be stated in separate paragraphs, Order 8, Rule 7, and when the ground is applicable. Not to the whole claim, but only to a part of it. Its statement should be prefaced. By words showing distinctly that it is pleaded only to that part of the claim. Thus, as to the Mesne profits claimed by the plaintiff, the defendant contends that, etc., or as to the price of cloth said to have been purchased by the defendant. Dear students, now let's understand what is the important part in the written statement. Important considerations while drafting a written statement are as follows. Point number 1. One has to deny the averments of the plaint petition which are incorrect, perverse, or false. If averment in any para of the plaint is not denied specifically, it is presumed to have been admitted by the other party by virtue of the provision of Order 8, Rule 5 of the Code of Civil Procedure 1908. It must be borne in mind that the denial has to be specific and not evasive one. However, general allegation in the plaint can't be admitted because of general denial. Number 2. If the plaint has raised an issue which is otherwise not admitted by the opposite party in the correspondence exchanged, It is generally advisable to deny such point issue and let the onus to prove that point be upon the other party. In reply, one has to submit the facts which are in the nature of defense and to be presented in a concise manner. Point number 3. Attach relevant correspondence, invoice, challan, documents, extracts of books of accounts or relevant papers as annexures while reply is drafted to a particular para of the plaint. Point number 4. The reply to each of the paras of the plaint be drafted and given in such a manner that no para of the plaint is left unattended. The pleadings are foundations of a case. It was held in Vinod Kumar versus Surjit Kumar, AIR 1987, Supreme Court 2179. Point number 5. It may be noted that if any of the important points is omitted from being given in the reply, it would be suicidal as there is a limited provision for amendment of pleadings as provided in Order 6, Rule 17 of the CPC. Point number 6. The reply written statement is to be supported by an affidavit of the party. This is mandatory. Likewise, the affidavit will be the sworn by any of the persons aforesaid and must be duly notarized by an oath commissioner. Point number 7. The reply along with all annexures should be duly page numbered and be filed along with authority letter if not previously filed. Point number 8. In every pleading, one must state specifically the relief which the party is claiming from the court. Or tribunal or forum. While framing the prayer clause, one should claim all possible relief as would be permissible under the pleadings and the law. So today we have covered the draft of written statement, and the next time we meet we will be covering writ petitions. Till then, keep learning, keep growing. See you next time.